Are you hitting the right notes in law? Hi, and welcome to the Law Simplified, the world's largest independent online law school platform. I'm your instructor, Shaveen Bandaranayakan. When it comes to an assignment submission or an examination for that matter, there are two fundamental, pivotal points that your examiner is always looking for. And if you are able to address these 2 points and these 2 requirements, you're not just going to pass your examination, but you're going to ace it altogether. If you like the type of content that I make on this YouTube channel, do subscribe to the Law Simplified and leave a comment below on what other types of content you would find helpful. If you are a first, second or third year law student, I would highly recommend enrolling in the comprehensive online law school platform, complete with theory, tutorial and workshop lessons based on the actual one-on-ones that I have conducted with first-class law students globally. These 2 pivotal aspects that your examiner looks for and addresses is the difference between passing an examination and acing it. And then collectively, if you are consistent in your approach from just passing or getting a second lower or a second upper to a first-class law degree overall. So, what are these 2 pivotal requirements? Firstly, have you addressed the learning outcomes for the module? Now, different universities and different jurisdictions will refer to this in different ways. They'll say learning outcomes, learning initiatives, what you ought to know at the end, module assessment criteria, examination criteria, and so on. They all boil down to one element: what the module is set out to achieve and what you as a student ought to show an examiner during an examination or a submission of an assignment. Now, you might think that this is abstract in nature, but on the contrary, this is a window into the examination technique anticipated and, more importantly, the marking scheme for that particular assignment submission or the examination. A lot of students gloss over this. They think of this as being just simple fluff, so to speak, or what the university is trying to outline as learning outcomes as simply being a requisite by law or by regulation. On the contrary, that's the guiding principle by which the module is assessed, and therefore, if you hit those right notes, so to speak, you are able to really capitalize on the marks that you receive. But that's only one part of the equation. The second thing that examiners look for, and the second point that they will address in determining your grade, is your articulation, your style of going about articulating the response as it relates to the question posed to you. What do I mean by this? Essentially, it's your personality and temperament of response. Not just personally who you are, but also whether it matches and whether it's appropriate for the type of module, for the type of question, and for the jurisdiction that you're answering it in. Now, on a number of different occasions on this YouTube channel, as well as the different platforms the Law Simplified is disseminated on, I've indicated how you can mold, so to speak, your temperament and the way in which you articulate responses. For those of you who have been my one-on-one fast track and masterclass students, in workshops and tutorials, for instance, we don't just break down a question, but also try and answer it in different ways based on the target audience. In other words, the type of examiner that we are addressing. So, on the one hand, some students prefer to outline all of the law at once and then subsequently argue it out piece by piece. This is a very direct form of going about things, and it might not be the most successful from a general context. Conversely, some other students prefer to weave the law, the facts and their arguments in a relatively conversational manner, whilst maintaining the academic rigor that's necessary in terms of the writing style. For 9 out of 10 occasions, this is what is recommended. The reason being, it gives you the capacity necessary to show off your skill and your knowledge as well. Because in the first instance, it feels a bit robotic and it feels pre-prepared and templated. Whereas in the second instance, it's more fluid and it feels like a conversation, and it also exudes a level of confidence on the part of the student as the examiner will see it. Because you're comfortable not only with the law and the facts, but your own opinion and arguments as well. So, to recap, an examiner is going to look at two fundamental things when it comes to an examination or an assignment submission. Firstly, have you addressed the learning outcomes or the module assessment criteria? Have you hit the right notes in terms of what that module and the examiner anticipates from you? Second, have you packaged and delivered your response in a manner that is appropriate for the module as well as the question posed to you? It's insufficient that you have one and not the other, because when it comes to a law exam, just like any melody, you have to hit the right notes in order to get the audience to notice you. That being said, until the next time that we speak, have fun, stay safe, and as always, obey the law.